Hello again, everybody, and welcome. I'm Professor Robert Romano, and this is part two of Constitutional Law and Freedoms, Module 5. If you're noticing the background is different, it's because I'm on the road and I'm at a lovely hotel room somewhere, not in my office. So let's continue. The U.S. Constitution, we talked about the First Amendment, all the different rights and privileges you are guaranteed as an American citizen under the First Amendment. And now let's talk about the Fourth Amendment. All right, the Fourth Amendment is the right of the people, meaning you, to be secure in your persons, houses, papers, and effects. That means yourself, your bags, your home, um, your purse, stuff like that, against unreasonable searches and seizures. And such shall not be violated, and no warrant shall issue but upon probable cause. Okay, so basically what that means is you cannot be searched unreasonably. It cannot be an unreasonable search unless the government has probable cause to search you or a warrant, and that warrant must be based upon probable cause. Okay, so it can be just walking down the street. When a police officer has probable cause, they see something that will give them probable cause to search you. That's fine as long as there is probable cause. Or if there's a warrant to search somebody's home, but that warrant has to be based upon probable cause. There's belief that there's drugs being sold out of the house. Okay, something like that. All right, the Fourth Amendment protects the right of the people from unreasonable search and seizure by the government. Okay, the government only. Private persons, private clubs, private establishments is different. It allows for the people to be secure in their persons, houses, papers, and effects. Okay? Reasonable searches are lawful. Search warrants based upon probable cause or warrantless searches are reasonable. All right? As long as the warrantless search is incident to an arrest or is in plain view. Or if the incident evidence is likely to be destroyed. All right, so what would be considered reasonable or lawful is search warrants based upon probable cause, but then again, that probable cause has to be substantiated. And warrantless searches can be considered reasonable if they're incident to a lawful arrest. All right, so after you're arrested and the police pat you down, they can search you so you don't have any weapons on you that may hurt the police officer. That would be an incident, a warrantless search incident to a lawful arrest. If the item is in plain sight, plain view. So let's say you get pulled over by the police, they look in your car and you have drugs on your passenger seat. Well, it's in plain view, right? That's reasonable. You see it. It's not, all right? Or if the evidence is likely to be destroyed. Let's say there's a drug deal on the street, the cops see it, guy runs into the house, drug dealer runs into the house, going to destroy the evidence, in the toilet or something like that. The cops can search because they believe that the evidence is likely to be destroyed. Okay, those would be considered reasonable and lawful. All right, all judged by the probable cause standard. Right, that's the standard that we use. Evidence that is found what is from an unreasonable search or a non-lawful search is not admissible in court. All right. So if the judge determines that that was an unreasonable search or a non-lawful search, it's not admissible. It doesn't come in. It's called the exclusionary rule. All right. So if the cops pull you over and there's drugs on the passenger seat, well, that was in plain view. That evidence is lawful. But if your drugs were in the glove compartment and the cops went through the glove compartment without a warrant, that would be unlawful and therefore not admissible under the exclusionary rule. The term of art is called fruit of the poisonous tree. Okay, that evidence came from is fruit of the poisonous tree. The search was poisoned. Everything that comes in after because of it is not admissible. The Fifth Amendment. All right, we talked about the first, the fifth, the first, the fourth, now the fifth. Fifth Amendment says no person in a criminal case has to witness against themselves. All right, you do not have to testify. So if you are arrested and you are going to trial, The prosecutor cannot pull you up onto the stand and ask you questions. Can't ask you, well, did you commit the crime? No. You have a right against self-incrimination, so you cannot be asked to witness against yourself. Okay? Take the fifth. You have all heard it on TV. You have a right to remain silent. Anything you say can will be held against you in a court of law. That's taking the fifth. You do not have to say anything. Non-testimonial evidence, however, is admissible. You do have to abide by it. Non-testimonial evidence, I mean getting fingerprinted, right? So if you're arrested, you're fingerprinted. Your body fluids can be taken from you. DNA evidence. Those are non-testimonial, what they consider non-testimonial evidence. That is not testimony, considered testimony against yourself, and therefore it is legal, and it is admissible in a court of law. The Fifth Amendment applies only to people, natural persons, not corporations, partnerships, or businesses. A business cannot take the fifth. A partnership cannot take the fifth. A corporation cannot take the fifth. All right? And that's a joke. Don't worry about it. You can always waive your Fifth Amendment's rights. You can testify. Usually when you do that, if you want to testify against somebody else, you may have committed a criminal act, but you witnessed to another criminal act, and that criminal act is more serious. All right, the prosecutors may say, we'll give you immunity. We will not prosecute you. In exchange, you waive your Fifth Amendment rights and you testify. Okay? Another aspect of the Fifth Amendment is double jeopardy. And that means once your case has gone to trial, and if you are found innocent or acquitted, you can never be tried for that crime again. All right? Meaning, even if new evidence pops up, even if a video pops up showing that you did it, no. Once you are tried the case and you are acquitted or found innocent by a jury, doesn't matter. The case is over. Even if more evidence shows up that shows that you did it, you cannot be tried for the case again. O.J. case. O.J. Simpson was acquitted of those murders. Even if now there's a video showing that he did commit these horrendous acts, these murders, it doesn't matter. He cannot be convicted again. Fifth Amendment also gives you privileges. All right, under the Fifth Amendment, you are given certain privileges. One of those privileges is an attorney-client privilege. What that means is that whatever you say to your attorney cannot be disclosed unless the client allows it. So if you're you get arrested, everything you tell your attorney, no one could call the attorney to the stand to testify what was said between the two of you. That's a privilege. That's a client privilege. That's a defendant privilege that they have. They can waive it, of course, but there's never a time where an attorney can be called as a witness against their client. Right? And the reason we do this is because it provides for a proper defense. You want to defend your client vigorously. And it just if the client is worried that you're going to be called as a witness against them later, they may not be as truthful with you as they could be or should be. And again, it can only be waived by the client. Other privileges out there are psychologists. You're going to a therapist. Anything you say in that therapeutical setting is fully privileged. Unless, there's an exception though, unless that the client tells the psychologist that he's going to kill somebody. Then you have a right to let that person know that their life is in danger. All right, priests, ministers, rabbis, what you tell your priest, your minister, your rabbi's privilege cannot come into court. Your spouse, there's a spousal privilege. What you tell your spouse cannot be called as a witness against you. Parent-child, same thing. You don't have to. You'll never be called to testify against your child. Okay. Sixth Amendment. Sixth Amendment is a right to a public jury trial. You have a right to a jury trial in a criminal case. You have a right to be tried by a jury of your peers, an impartial jury. You also have a right to confront and cross-examine anybody who testifies or witnesses against you. The Confrontation Clause means you have a right to ask that witness questions. You have a right to ask them, to impeach them, to show bias. They may testify and they may say some damaging stuff against you, but you have a right to ask them questions about anything that may show that their testimony isn't as strong as it seems to be. Okay? You have a right to alert. You have a right to a speedy trial. All right? You cannot sit in jail for 4, 5, 6, 7 years. You have a right to a speedy trial. If you get arrested and cannot make bond or make bail, you have a right to a speedy trial. And that usually means within 70 days of being arrested. All right, your Eighth Amendment. Eighth Amendment is the right against cruel and unusual punishment. We cannot torture criminals. It's a little. Think about this with the Guantanamo Bay scenario, waterboarding, stuff like that. But under the Eighth Amendment, you have a right as a person against cruel and unusual punishment. Think about this in the context of the death penalty too. Is that cruel or unusual? I'm not going to make a judgment on it. I believe that it is cruel to kill somebody, but some states don't. Texas likes to kill everybody. The 14th Amendment of the United States. Now we're outside the Bill of Rights. The Bill of Rights is the first 10 amendments. The 14th Amendment is the Equal Protections Clause. All right. It says you cannot deny any person within its jurisdiction equal protections of law. Everyone is entitled to the equal protection of law. You can't say this person isn't entitled to it or this person isn't entitled to it. No. Every person is entitled to equal protection. All right. It's based upon similarly situated people. There are three different classes, however. Suspect classes, protected classes, and other classes. The book does a good job of going over the different similarly situated people. And let me just give you an overview right now. Suspect class. You cannot make a law that's based upon race. You cannot say, well, this race of people cannot get health care. Or this set of people based upon race cannot go to college or cannot get public education. All right, that's a suspect class. Any law that says that is going to be reviewed under strict scrutiny and knocked down. All right, you cannot cannot single out a certain race of people and say they are not entitled to a certain benefit. That's a suspect class. And they're not being provided the equal protections of law, and therefore that law will be stricken. Protected classes, all right, gender or age. Laws based upon gender or age will be reviewed under intermediate scrutiny. There may be reasons why we need to have different laws for different genders or different laws for people of different ages. So they're going to be looked at. And maybe they're not equal, but in certain circumstances it makes sense, so it's going to be upheld. If it doesn't make sense under the intermediate scrutiny test, it'll be found to be unconstitutional and stricken down. All right, there are certain times when, certain laws for women make sense. Certain laws for men make sense. Certain laws based upon your age make sense. Like those under the age of 18 cannot vote. Those under the age of 18 cannot enter into a contract. Okay, those are laws, but there's a reason for it. And it's a pretty legitimate reason. So we're going to allow this law to be on the books. If the law is reasonably related to a legitimate government purpose under the intermediate scrutiny test, it will be allowed under the Equal Protections Clause. It will not be deemed to be a violation of the Equal Protections Clause. All others are reviewed under the rational basis and is legal as long as there is a justifiable reason for the law. Okay? Both the 5th and the 14th Amendment also contain a due process clause. All right, you cannot be denied life, liberty, or property without due process of law. Receiving what process is due. Somebody cannot just come in and take your property. They can't take your home. They can, but you have to have a hearing first. A judge, an impartial party, has to say there's a reasonable reason why this has to happen. they're going to build a highway and your house just happens to be in the middle of the highway, they may say, yeah, we're going to take your property, but we're going to give you compensation for it. Okay? You cannot be denied life, liberty, or property without the due process of law. Okay? Read in the book what the 5th and 14th Amendments say. There's a difference between procedural due process, where you have to have a notice, a hearing, and therefore you cannot be deprived life, liberty, or property without notice and without a hearing. You have a right to state your case. You have a right to say, no, you can't take my house. The highway should go that way, or whatever it is. Okay? Don't worry about privilege and immunities clause. It's not going to be on the quiz. This will be part 2 of Constitutional Law and Freedoms. Read it, review this again. It's a lot of stuff. Review it with the book. There are going to be a lot of questions on the next quiz about constitutional law. But in the Dropbox, you need to answer the following questions. So I'm aware that you reviewed this. The question is, how many U.S. senators are sitting in Congress down in Washington, D.C.? The answer, 100. All right, so in the Dropbox, place 100. You get your point. Thank you. Take care.